The exclusionary rule is a legal principle which holds that evidence obtained in violation of the Fourth Amendment is not admissible in criminal proceedings. The purpose of the exclusionary rule is to deter police misconduct. If evidence is not admitted, police misconduct will be minimized. In Weeks v. United States, 1914, the Supreme Court held that illegally obtained evidence by federal officers would be excluded in federal criminal proceedings. From 1914 until 1960, federal courts admitted evidence that had been obtained illegally by state officers. This practice would end in Elkins v. United States, 1960. In Silverthorne Lumber Company v. United States, 1920, the court developed the fruit of the poisonous tree doctrine, which held that any evidence that derives from illegally obtained evidence was also inadmissible. And then in 1961, the Supreme Court decided Mapp v. Ohio. In this case, the law enforcement officers were state officials, and this decision was a landmark decision because it held that the exclusionary rule is an essential part of both the Fourth and 14th Amendments and applied to the state level. The exclusionary rule is not applicable in all situations. There are exceptions such as good faith and inevitable discovery. The exclusionary rule also does not apply to all Fourth Amendment proceedings. For example, the exclusionary rule does not apply and illegally obtained evidence will not be admitted in violation of knock-and-announce rules, in grand jury investigations, in sentencing decisions, when it's a violation of an agency rule, when it involves a civil proceeding, or if it involves a probation or parole revocation hearing.